natirang medium period. Pag may natirang mitigating circumstance minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natirang medium period, pag may natirang mitigating circumstance, minimum period. So, ganun lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang epekto, maximum period. Offset rule, i-offset mo muna. Tingnan mo kung ano yung remaining modifying circumstance. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1, exception.
You have to be guided by Section 1 of Rule 138 because Rule 138 is one of the sources of legal ethics. Who may practice law? Ang sinasabi dyan ay any person heretofore duly admitted as a member of the bar or hereafter admitted as such in accordance with the provisions of this rule and who is in good and regular standing is entitled to practice law. Iyan po iyon. That is ULEP versus Legal Aid Clinic. ULEP versus Legal Aid Clinic. Okay? Yan yung doktrina. Alin yun, sir? Yung any person. Kasi any person may mean na pwede palang mag-practice. Kung hindi yan natin makokorek, pwede palang mag-practice ang juridical person. So let us disabuse.
The shares of XYZ, the 40% shares of XYZ, likewise owned by the same foreign corporation owned by foreigners that directly owns 40% of ABC Corporation. So to repeat, let's say the foreigners, right? The foreign held corporation owns 40,000 of 100,000. At the same time, the foreign held corporation owns 40% of XYZ share in ABC Corporation. So the question now is, based on these figures, is ABC a Philippine national? Is it qualified to invest in public utility? Is it compliant with the Constitution?
So, of course, my friends, you have, of course, a reply. To make it simple, a reply is an answer to an answer. Ayan. And the purpose of the reply is to transverse new matters raised in the answer. Transverse, dispute, di ba? Contest, transverse, new matters raised in the answer. But even though you fail to file a reply, under the new rules, no? If you fail to file a reply, okay lang. Kasi exceptional situation lang. Ang rule na ngayon, all new matters alleged in the answer are been controverted already. So maski walang reply, all matters raised in the answer are being controverted already. If you talk
in relation to dation in payment, the answer is yes, because the debtor would offer another thing. Example, if the thing to be delivered is a sum of money like 20,000, the debtor instead would offer his carabao in payment of his debt, and therefore the consent of the creditors is absolutely necessary. Okay, he may not want the carabao. Okay, but in application of payments, is the consent of the creditor required? Definitely, there is no question because he would accept. Okay, then there is consent. However, okay, the question that would have to be answered is to which debt the payment should be applied. The third
Together we can.
Walang natira video. Pag may natirang mitigating circumstance minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natirang medium period, pag may natirang mitigating circumstance, minimum period. So, ganun lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang epekto, maximum period. Offset rule, i-offset mo muna. Tingnan mo kung ano yung remaining modifying circumstance. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1, exception.
our dear attendees from different parts of the country. I pray that you're all in great state of health. This free webinar is streaming live via the VLC Law Center's YouTube channel and Facebook page. If you can hear my voice clearly, please type in the comment section #VLC. Thank you. Yes, thank you. Optimize this learning opportunity. Share this free online lecture to your friends and together learn at the comfort of your homes. I want to formally welcome you all to this free webinar. This is part of a series of free online lectures brought to you by the Virtual Law Companion of VLC Law Center. Allow me to share to you this good news. The Virtual Law Companion is the newest innovation of VLC Law Center, which aims to provide an easy, convenient, and quality bar review experience. The Virtual Law Companion is a web application that is hosted on a dedicated cloud server. It can be accessed via the internet 24/7 for any web browser using any device or handheld computers like Android or iOS phones. Meaning, you can study anytime, anywhere, and from any mobile device. Please visit our website at www.vlclawcenter.com to know more about our programs and activities. Before we formally start, please take note of some reminders. First, this free webinar is pre-recorded to ensure the uninterrupted streaming of lectures. Secondly, VLC team will be with you to assist you should you need more information about our program. Please visit and subscribe to our YouTube channel and Facebook page. Without further ado, please give your virtual claps and welcome our lecturer today. Again, this free webinar is brought to you by our Virtual Law Companion. Maraming salamat po. Together, we can make things happen. Together, we can.
Good day to everyone. Welcome to the VLC Law Center free online bar lecture. So for today, we will talk about civil procedure, more particularly with emphasis on the 2019 Amended Rules under AM number 19-10-20-SC. So for today, I'll be discussing civil procedure, basically the story of civil procedure. Don't expect me to discuss it the way it is written, like Rule 1, explain, Rule 2, Rule 3, Rule 4. I'm going to present to you civil procedure, how it operates. So let's start. Civil procedure, of course, starts with a complaint. And in filing a complaint, of course, we need to know if we have cause of action. We have cause of action, the following requisites should be present. There must be right on the part of the plaintiff, obligation on the part of the defendant, and breach. And of course, we will go into discuss what is the effect if there is an improper joinder of causes of action, what is the legal implication if there is a misjoinder of cause of action, what are the relevant rules insofar as to splitting a single cause of action, and after that, cause of action, we will go to jurisdiction, more particularly with RA number 11576, which took effect on July 2021. We will discuss basic rules on jurisdiction and determining the jurisdiction, particularly over the subject matter. After that, we will discuss proper parties that should be impleaded. Of course, if you will file an action, you should implead the proper parties, those who are a real party in interest, those who have been benefited or injured by the decision. The legal effect of that is it is prone to an answer with an affirmative of failure to state the cause. We will discuss that. And after that, we will be discussing else venue. Of course, we will discuss how to determine venue. Of course, we should first determine if it is a personal action or if it is real action. Real action, which is an action which involves Title II, possession of real property or any interest therein. Of course, we will discuss exclusivity as to venue. And then after that, we will proceed with the start of the 2019 amended rules, which started under Rule 6 with regards to preparation of a pleading. Because under the present rules, it is not only concise statements of the cause of action that should be stated in the complaint, but also evidentiary facts such as names of the intended witnesses, their judicial affidavits, documentary and object evidence. We will discuss that. And of course, preparation of certificate against forum shopping, preparation of a verification, and we will also discuss what is the significance of a lawyer's signature in every pleading, which is new under the 2019 amended rules. So after that, we already have our complaint. The second stage would be after filing it, the second stage is the issuance of summons. So, anong bago dun sa 2019 amended rules? Under the 2019 amended rules, after filing of the complaint or receipt of the court, the clerk of court is obliged to issue to serve summons within 5 calendar days from the filing of the complaint. Okay, so meron na tayong period doon of 5 calendar days after receipt of the complaint, kailangan mag-issue na ng summons si clerk of court. In summons, as the second stage of civil procedure, we will discuss in rem action, quasi-in rem action, in personam action. What is the relevance of that? Because if it is an in personam action, we have the following hierarchy of service of summons. Must be in person. Service of summons in person of the defendant. Number 2, the defendant is in his residence but refuses to receive the summons by tendering it in his presence and in his view. After that, if the defendant is not in his residence, first there is substituted service of summons. After at least 3 tries on 2 separate dates, kung mayroong impossibility of prompt personal service, then the sheriff may opt to do this substituted service of summons. We will discuss what are those modes. After that, we will also discuss the service of summons upon an individual and service of summons upon a private domestic jurisdiction entity kasi magkaiba sila lalo na in terms of substituted service of summons. What else? So after summons, supposed to be answer. But before the defendant will file his responsive pleading to the complaint, which is his answer, maraming mga possible important topics na pwede pumasok. Like, for example, the defendant may file a motion for bill of particulars. The complaint is vague or ambiguous in order for the defendant to file his responsive pleading. Pwede pumasok yung principle ng motion for particulars. What else? Pwede rin pumasok if the defendant or if the plaintiff wanted to amend his complaint. Siyempre, papasok yung principle ng amendment of pleadings. The basic rule in amendment of pleadings is that amendment of a pleading is a matter of right once before a responsive pleading has been served. Okay? Another important topic that we will discuss is what if after the filing of the complaint, okay, the plaintiff wanted to dismiss his own complaint. So possible, papasok yung Rule 17. So the dismissal of the plaintiff of his own complaint is a matter of right by mere notice if there is yet no service of an answer or there is yet no service of a motion for judgment on the pleadings. Motion for summary judgment. Sorry. Motion for summary judgment. So it is a matter of right on the part of the plaintiff to dismiss his own complaint. However, if there is already service of an answer or there is already service of a motion for summary judgment, still the plaintiff can dismiss his own complaint as a matter of discretion naman. In such case, the plaintiff will file a motion to dismiss his own complaint. And what else? Of course, we will discuss yung two dismissal rule. Then after that, we will discuss yung dismissal because of the fault of the plaintiff, yung apat na motu proprio dismissal because of the fault of the plaintiff, such as number 1, if the plaintiff fails to be present at the date of his presentation of his evidence in chief. Number 2, if the plaintiff fails to prosecute within unreasonable length of time. Number 3, if the plaintiff refuses to obey the lawful order of the court. And number 4, if the plaintiff fails to comply with the rules of court. So yung mga motu proprio dismissal due to the fault of the plaintiff. What else? Summons before answer. Ano bang possible? What if the defendant fails to file an answer? Papasok din yung principle ng default. So default, of course, the court cannot declare the defendant motu proprio default. Why? Because the plaintiff should first file a motion to declare the defendant in default. Okay, so during that period, kung meron nang naka-file na motion to declare the defendant in default, the defendant may opt to immediately file an answer, or since a motion to declare the defendant in default is a litigious motion, then the defendant may file an opposition. Within how many days? Within 5 calendar days from receipt of the motion. So, what else? What if the motion to declare the defendant in default was granted by the court? So, magkakaroon na ng order of default. What is the effect of order of default? The defendant loses his standing in court in the sense that he cannot present evidences, hindi niya na pwede i-cross-examine yung mga yung witness ni plaintiff. What else? And of course, the only right that the defendant can have is to receive notices. And of course, to file a motion to lift or set aside the order of default. So, yun yung remedy ni defendant in case there is already an order of default. Take note, yung first stage na kanina, hindi nakapag-file ng answer within the reglementary period, walang motu proprio declaration from the court declaring in default, kailangan mag-file ng plaintiff na motion to declare the defendant in default. So, pag nag-grant yung motion to declare the defendant in default, magkakaroon ng judgment by default. Okay, meron pa rin bang remedy si defendant? Of course, meron pa rin. MR, motion for new trial, appeals. Okay? And if the judgment is already final and executory, the defendant may opt to file a petition for relief from judgment or a petition for annulment of judgment. Okay? So, someone's answer, we've discussed yung motion to amend the pleading, dismissal by the plaintiff, motion for bill of particular, default, and of course, we will discuss the important rules on motions, okay, which is very important under the 2019 Amended Rules. To give an overview, a motion, it can be a motion made in open court or a motion can be a written motion. So, magkaiba yung rule niya. Just to give an overview nga, yung motion which is made in open court or verbalized or oral motion, ano ba ang rule natin dyan? The court should immediately resolve the motion made in open court. Paano? In open court din. Pero meron tayong a requirement that the other party should be given first a chance to argue or to oppose with the verbalized or oral motion. Okay? Ano ang exception? Exceptions are saan? In an oral motion, in a verbalized motion, in a motion made in open court, But first, the other party should be given a chance to oppose. After that, the court will immediately, okay, rule or resolve it in open court. What is an instance wherein the court can conduct a hearing? If the subject of the motion made in open court is not appearing on the facts of the records of the case. Siyempre, anong pagbabasihan ni judge? So in that case, the court can conduct hearing by deposition, affidavit. So yun yung verbalize or motion made in open court. Second kind of motion is the written motion. If we talk about a written motion, of course, we have two kinds. A litigious motion and a non-litigious motion. Of course, a non-litigious motion, it is a motion wherein if it is granted by the court, the other party will not be prejudiced. Litigious motion, syempre pag ginrant ni court, the other party will be prejudiced. Now, what are some basic rules? If it is a non-litigious motion, of course, it is a written motion. Pag non-litigious siya, okay, the rule is that no opposition is required because the court should resolve it within 5 calendar days from receipt. Hindi na maghihintay ang korte ng opposition from the other party. Rational because hindi naman siya it will not prejudice the other party even though it will be granted. Okay? Now, if it is a litigious motion or a contentious motion, in such case, the court will or the other party will be given a chance to oppose within 5 calendar days from receipt of the motion. Okay? So, ika-copy furnish ni movant si other party. Pagka-receive ni other party nung copy nung litigious motion, meron siyang 5 calendar days to oppose. Then after that, from receipt of the court nung opposition ni kabilang party, the court has 15 calendar days to resolve the motion. Okay? So what if the other party hindi nag-file ng opposition? The court will wait for that 5 calendar days to expire. Then after that, magkakaroon ng 15 calendar days si court to resolve the litigious motion. Okay, so that's about motion. What else? So basically, yun yung mga topics na di-discuss natin between summons and answer. Let's go to the third stage ng civil procedure, yung filing of a responsive pleading, which is called an answer. Answer is a responsive pleading to the complaint. Basically, ano yung mga di-discuss natin topics? Of course, yung mga effective and defective answer. If we talk about effective answer, those are defenses which is provided by the rules of court, such as negative defense. And of course, if we talk about negative defense, this is a specific denial of the material allegations in the complaint. So, pag ganun yung ginamit ni defendant sa kanyang answer, it is an effective defense. It will not constitute as an admission. Another effective defense is yung bago rin ngayon under the 2019 Amended Rules, yung affirmative defenses. Okay, it is effective kasi it is provided by the rules of court. And an affirmative defense, it is wherein the defendant is hypothetically admitting the material allegations in the complaint, but which nevertheless, it will bar or prevent recovery. Kasi nga, meron siyang defenses na affirmative. But if we discuss affirmative defense, syempre, we will divide it into two. Because we have two groups of affirmative defenses. The first group is under Rule 6, Section 5B. And the other one is Rule 8, Section 12. Yung Rule 8, Section 12, 5 lang ang grounds natin doon. Under Rule 8, Section 12, first ground is lack of jurisdiction over the person of the defendant. Number 2, proper venue. Number 3, failure to state a cause of action. Number 4, lack of legal capacity to sue. And number 5 is failure to comply with the condition precedent. That is the second group of affirmative defense. First group of the affirmative defense is yung Rule 6, Section 5B. Ano yun? Yung fraud, statute of fraud, statute of limitation, waiver, payment. And that Rule 6, Section 5B is not a closed list. Okay? Now, it is divided into two because yung first group, yung Rule 6, Section 5B, pag yun yung ground ni defendant sa kanyang affirmative defense, the court may opt. So, it is discretionary upon the court to conduct a summary hearing. So, pwede mag-summary hearing si judge noon within 15 calendar days from receipt of the answer with an affirmative defense. Okay, pero pwede rin bang hindi siya mag-conduct ng summary hearing? Pwede rin. In such case, pagka-receive niya nung answer with an affirmative defense in defendant and hindi siya magkakandak ng summary hearing, meron siyang 30 calendar days. Okay? 30 calendar days to resolve whether or not to grant or to deny yung affirmative defense. That is with regards to the first group of the affirmative defense, Rule 6, Section 5B. Second group natin, the court, yung Rule 8, Section 12, the court cannot conduct a summary hearing. In such case, the court should resolve the affirmative defense within 30 calendar days. So, hindi na siya pwede mag-conduct ng summary hearing. Mamaya, we will explain what is the rationale of that. Okay? So, answer. After the answer, if there is an actionable document attached to an answer, pwede mag-file si plaintiff ng reply. Okay? A reply is, under the present rule, a prohibited pleading. Why is it prohibited? Because it is only allowed if there is an actionable document attached to an answer. Kung walang actionable document, what is an actionable document? It is a document which is the basis of the claim or basis of the defense. What is a good example of that? Basis of a claim. Let's say the action is collection of sum of money. So usually, ano ba document na ginagamit ni plaintiff doon? Promissory note. Okay? If it is a basis of the defense, si defendant, tatanggi niya yung utang, ano ba yung usual na document na pinapresent ni defendant? Perhaps an acknowledgement receipt. Okay? So anyway, so why is it that a reply is a prohibited pleading, as I have said? Kasi nga, it is only allowed if there is an actionable document attached to an answer. Okay? And other than that, it is no longer allowed because basic is the rule that all new matters alleged in the answer are deemed controverted by the rules of court. So there's no use for the plaintiff to file a reply kung wala namang actionable document. Third reason, kasi pag may actionable document sa answer, okay, yung caudal natin, sa rules of court mismo, hindi naman siya pwede magpunta kay notary public to deny the actionable document attached to an answer under oath. Diba? Basic is the rule that if you want to deny an actionable document, you must deny it under oath. Otherwise, the genuineness and due execution of such actionable document is deemed admitted. Take note, what is admitted is the existence of the actionable document, not what is stated on the actionable document. So, reply. What if there is an actionable document attached to our reply? Then, the defendant can file a rejoinder. Why am I talking about the last possible pleading? Kasi after the last possible pleading, okay, papasok na yung next stage ng civil procedure, which is the pre-trial. And pre-trial, although it contains a kilometric words, sentences, 2019 Amended Rules, pre-trial under the 2019 Amended Rules is only 5, 3, 60, 10, 10, then 90, 30, 15. Sir, ano ba yun? Isa-isahin natin. Pre-trial is 5. Ano yung 5? 5 calendar days from receipt of the last responsible pleading from receipt ng court within 5 calendar days. So, meron na tayong period. The court should issue a notice of pre-trial. Kailangan meron ng notice of pre-trial si court to be served to both parties. Okay, so yun yung 5 calendar days. 5 is equivalent to notice of pre-trial. What is the next number? Number 3. What is 3? At least 3 calendar days, okay, the parties should serve and file their pre-trial brief. So when we talk about 3 calendar days, it is about the pre-trial brief that should be filed and served by the parties. Okay, so 5-3. Next number would be 60. What is this 60 calendar days? It's about the setting of the pretrial. Because under the rules, the court should set the pretrial, okay, within 60 calendar days reckoned from the filing of the last pleading. Okay, so after 60, meron tayong dalawang possible scenarios. Okay, first is yung 10, the other one is yung 10. Doon muna tayo sa first scenario, ano ba yung 10 na yon? That will come into the picture if one of the parties, more particularly the defendant, is absent. Okay? So during the pre-trial, pag si defendant ay absent, okay? Doon muna pala tayo si plaintiff. Si plaintiff is absent during the pre-trial. Of course, the legal implication would be it will be adverse against him. So the case will be dismissed, generally with prejudice. Pag absent si plaintiff during the pre-trial, it will be dismissed generally with prejudice unless it is otherwise stated by the court. Yun kung absent si plaintiff. If si defendant naman ang absent, doon papasok yung 10 calendar days. If the defendant is absent during the pre-trial, the plaintiff is given a chance to present his evidence ex parte within 10 calendar days from the termination of the pre-trial. So yun yung 10 calendar days dun sa first scenario natin. Pag absent si defendant, si plaintiff should present his evidence ex parte within 10 calendar days reckoned from the termination of the pre-trial conference. Okay? Ano yung second scenario natin na 10? 10 calendar days kung present naman si plaintiff and si defendant during the pre-trial. Ano yung 10 calendar days? You can put there pre-trial order. Okay? Yung pre-trial order na yon, meron tayong what is our legal basis? Under the rules, under Rule 18, the court should issue its pre-trial order within 10 calendar days from the termination of the pre-trial. So pag natapos na yung pre-trial, meron 10 calendar days si judge to issue his pre-trial order. Okay? And in that pre-trial order, within 10 calendar days, meron tayong dalawang scenario, 90 calendar days and then 30 and 15. Okay, sir, ano yung 90 calendar days? Let's see the pre-trial order. If it is stated in the pre-trial order that the judge is going to render a judgment on the pleadings under Rule 34 or a summary judgment. Okay? Pag nilagay ni judge sa kanyang pre-trial order na magre-render siya ng summary judgment under Rule 35 or judgment on the pleadings under Rule 34, okay? Within 90 calendar days, okay, the judge or the court should render the judgment. Okay? So magkaiba yung order, pre-trial order indicating therein na magre-render siya ng Rule 34 or Rule 35 and yung judgment mismo. Yung judgment must be made within 90 calendar days. Okay? Yung second scenario natin, yung 30 and 15. That is if dun sa pre-trial order, there was no statement about rendering a judgment on the pleading or summary judgment. Kung wala naman nakalagay dun sa pre-trial order niya, papasok yung 30 and 15. Ano yung 30? Yung 30 is about yung court annex mediation. So, it is non-extendable of 30 calendar days. Then after that, if necessary, they will conduct JDR, Judicial Dispute Resolution, which is not extendable for 15 calendar days. Okay? Then after that, what is the next stage? So, tapos na tayo sa pre-trial, sa trial proper na tayo. So, sa trial proper, we will discuss later, ano ba yung 30, 90, 30, 90. So, we will discuss that later. After the trial stage, syempre, meron ng judgment. Okay? Judgment, after judgment is the story of civil procedure. Will it end there? Judgment, of course, no. Because we have the next stage, which is the post-judgment remedies. And under the post-judgment remedies, we have the following remedies. Let's determine first if the judgment is final or if it is final and executory. Because if the judgment is already final but not yet executory, we have the following remedies. Number one, motion for reconsideration, or the adverse party may opt to file a motion for new trial, or the party may file an appeal. Okay? But if the judgment is already final and executory, we still have two remedies. First is we can avail petition for relief from judgment, or we may opt to file a petition for annulment of judgment if the judgment is already final and executory. Okay? Then after that, post-judgment remedies, dito na tayo sa last stage ng civil procedure, which is execution. Okay? So, that is the overview of my lecture for today. So, let's start the lecture. Okay, so let's go now again with the first stage of civil procedure, which is a complaint. And as I have said, before you can file a complaint, you should have a right of action. And in order for you to have a right of action, syempre you should have a cause of action. Now, what is a cause of action? Of course, we should remember yung three requisites ng cause of action. First is the right on the part of the plaintiff. Number two, a correlative obligation on the part of the defendant. Number three, breach. Okay, so yun yung basic rules natin sa cause of action. Now, what is the significance? Excuse me. What is the significance of knowing the requisites of a cause of action? It is because if there is an absence of any of the requisite, the defendant will have can file an answer with an affirmative defense of failure to state a cause of action. So therefore, the affirmative defense of failure to state a cause of action, it can arise if there is an absence of any of the requisite of a cause of action. So, what is the legal effect if you join several causes of action in one complaint? What are the basic rules? So, let's talk about joinder of causes of action. If there is a question in the bar exam regarding joinder of causes of action, meaning to say, can you file one complaint involving 2, 3, 4, several causes of action in one complaint? Or what are the basic rules that we should take into consideration so that we can have a valid and not a misjoinder causes of action? So first of all, I would like you to note what we call the one-on-one. Number two, the multiple parties. Number three, you should not join an ordinary action with a special civil action, or those rules, those which are governed by special rules. Number four, we should also comply with the totality rule. Number five, we should, I call it respect of venue and jurisdiction. Okay, so let's have an illustration. So for example, here comes P1 versus defendant 1. Okay. Can he file an action for specific performance? And nangutang din si D1 kay P1 ng, let's say, 2.5 million. Okay, what else? Hiniram ni D1 yung kotse ni P1, and then because of negligence, nasira niya. So, he wanted to claim let's say, damages of, let's say, 3 million. Si Ferrari yung kotse. So, question, pwede ba i-file ni plaintiff yung kanyang complaint joining these three causes of action? Another question, what about si P1? Let's say here comes three friends. Let's say D1, D2, and D3. Okay? They wanted to form a business. So magkaka-partner sila, si D1, D2, and D3. So they wanted to borrow money from P1. Let's say they borrowed 1 million pesos jointly. Meaning to say, the promissory note states that we, D1, D2, D3, promises to pay P1 3 million pesos on or before blah blah blah. Okay, so 3 million. Joint. Okay? Sabi, we promise to pay. Then, naging due and demandable. Hindi nakapagbayad si D1, D2, and D3 kay P1. Of course, kanya-kanya silang kanya-kanya silang utang diyan, in the sense that D1 meron siyang 1 million na utang kay P1, D2 1 million, D3 1 million. Okay? But can P1 join these three causes of action in one complaint? Okay, that's the second question. Third question, silang same cast tayo, si P1 versus D1, D2, D3. Okay? Ito naman, since si D1, he needs fund for his business, he borrowed 1 million kay P1. Ito naman si D2, because he wanted to construct a house, he borrowed, let's say, 1 million pa rin kay P1. Si P3, because he wants to, let's say, buy a car, he borrowed 1.5 from P1. Okay. May magkakapit-bahay sila. Naging due and demandable, hindi nila nabayaran si P1 despite of serving a demand letter. Due and demandable, nagbigay na ng demand letter si P1. So P1 ask you, can he join these three causes of action in one complaint? Okay? So, if that would be the tenor of the question in your bar exam, how will we approach it? So, as I have said, if the question is about joinder of causes of action, take note of the five rules that should be taken into consideration. So, ano yung sinabi ko kanina? One-on-one, multiple parties, don't join a special civil action with an ordinary action. Number 4, totality rule. Number 5, respect of venue and jurisdiction. Okay? So, ano ba yung one-on-one? When there is only one plaintiff and one defendant, okay? There's only one plaintiff and one defendant, you can join as many causes of action, okay, in one complaint. Of course, provided that you will not join a special civil action or any action which is governed by a special rule. Okay? So, pwede pagsamasamahin ni P1 yung mga complaint na yon, yung mga causes of action na in one complaint, kahit na it does not arise from the same transaction or series of transactions, even though it does not involve common question of fact or law. But, number 2, multiple parties. If we have several plaintiff or we have several defendants, okay, pwede ba mag-join ng maraming causes of action in one complaint? Yes. Provided that it arises from the same transaction or series of transactions, and it involves common question of fact or law. Okay? So, sir, what is the rationale of that? Why is it that meron kang one-on-one, meron kang multiple parties? Because first rule in joinder of causes of action is that you should comply with the rules on joinder of parties. Okay? So, magkaiba yung joinder of causes of action and then yung joinder of parties. Okay? So, ano ba yung joinder of causes of action? You should comply with yung rules na in-enumerate ko para maging valid yung joinder of causes of action mo. On the other hand, if we talk about joinder of parties, you can join parties provided that it arises from the same transaction or series of transactions and it involves common question of fact or law. So, what is the relevance of that? As I have said nga, para magkaroon ng valid joinder of causes of action, you need to comply with the rules on joinder of parties. And if we have multiple parties, we can comply with such rule. Meaning to say, you can join yung mga parties na yun provided that it arises from the same transaction or series of transaction. But if it is a one-on-one situation, there's only one plaintiff and there's only one defendant, okay, you need not to comply with the rules on joinder of parties. Why? Because dahil one-on-one lang sila, hindi mo naman sila pwede pag-joinin. Kasi magkalaban sila. So the rules on joinder of parties will not be applicable. Okay? So that's those are the first two rules. Third rule, okay? Don't join an ordinary action with a special civil action or with an action which involves special rules. So, basic. In this case, paano kung merong D4? Si D4 ay co-owner ni P1. Okay? So, ang gusto niya i-file ay partition. Partition. Okay? And dahil magkakapit-bahay si D1, D2, D3, and D4, gusto i-join ni P1 sa isang complaint itong 4 na causes of action. Of course, it will not comply with the rules on joinder of causes of action kasi it will violate yung third rule. You cannot join an ordinary action with a special civil action. Okay? Simple as that. Sir, what about yung fourth rule natin? What is our fourth rule? It is about the totality rule. Sir, what is the totality rule? Totality rule, if there are several causes of action, so maraming causes of action, okay? But take note, all of them should be principally for money claims. Kailangan money claims lang siya. Okay? The aggregate amount, so i-add natin, the aggregate amount shall be the test of jurisdiction. So yun yung totality rule. So kung pwede mo siya i-join multiple parties or kahit isang party lang pero marami naman yung cause of action, and all of them are principally for money claim, i-add mo lahat yon and that will determine what court will have jurisdiction. Okay? So that's the fourth rule to comply with the rules on joinder of causes of action. Number 5. Sir, ano yung respect of venue and jurisdiction na sinasabi mo? Under the rules of court, in order to have a valid joinder of causes of action, if there are several causes of action, okay? Number 2, involving the same parties. Number 3, if those causes of action belong to a different venue or belongs to a different jurisdiction. Okay? Number 4, but one of the causes of action falls within the RTC. Okay? Kahit na maraming causes of action involving the same parties, and yung mga iba't ibang causes of action na yon, iba-iba yung jurisdiction, may MTC, may RTC, may MTC, may MTC, may RTC. Okay? Different venue rin. Okay? Provided that one of the cause of action falls within the RTC, you can join them kung valid yung joinder of cause of action, meaning to say, nag-comply ka with Rule 1, Rule 2, Rule 3. Ano yung first rule natin? One-on-one, multiple, do not join an ordinary action with a special civil action, totality rule. Nag-comply ka lahat doon. Saan mo siya ipa-file? You can file it provided that isa doon ay nagko-fall sa RTC. You can file it at in that RTC provided that the venue also lies therein. Okay, so yun yung tinatawag ko. So you should respect the jurisdiction and the venue. What is a good example of that? Let's say collection of 1.5 million. So P1 versus D1, first cause of action, collection of 1.5 million. Okay? Second cause of action is magkapatid sila kunwari, co-ownership. Let's say recovery. Gawin na lang natin recovery of real property. Okay, worth 3 million. Okay, recovery of real property 3 billion. So again, P1, D1, first cause of action is collection of money worth 1.5 million. And then recovery of real property worth 2.5 million. P1 is residing at Quezon City. D1 is residing at Manila. And the property involved is located at, let's say, Pasig. Okay? Pwede ba natin i-join yung dalawang causes of action in one complaint? Ano yung first cause of action? Collection of 1.5 million. Second cause of action, recovery of real property worth 2.5 million. So, one-on-one. So, kahit na hindi nag-arise sa same transaction or series of transaction, pwede mo siya i-join. Kasi it need not to comply with the rules on joinder of parties. Okay? Second, lookout natin. Meron ba dyang special civil action? Wala naman. Collection of 1.5 million, collection of sum of money. Number 2, recovery of real property, which is also an ordinary action. So, okay lang. Pasok pa rin tayo. Totality rule. Papasok ba ang totality rule? There are several causes of action and all of them must be principally for collection of money. The aggregate amount shall be the test of jurisdiction. Papasok ba yung given facts natin? Hindi. Kasi recovery of real property naman yung isa. So, walang totality rule. Okay? So, paano, sir, ma-apply yung fifth rule natin? Yung respect of venue and jurisdiction. So, ano yung first requisite natin? Several causes of action. So, meron tayong dalawang causes of action involving the same parties. So, check. Okay? Number 3, different venue and different jurisdiction. Present ba sa case natin? Yes. Why? Because yung first cause of action natin, collection of sum of money of worth 1.5 million, what court has jurisdiction? MTC. Okay? Because it is 2 million and below under RA 11576. The other one is recovery. Yung second cause of action natin is recovery of real property worth 2.5 million. So since it is more than 400,000, kasi it involves title to possession of real property or any interest therein, RTC ang may jurisdiction. So magkaibang jurisdiction. Magkaiba rin bang venue? Magkaiba rin ang venue. Why? Because the first cause of action natin, personal action. It does not involve title to possession of real property or any interest therein. So ang venue natin ay residence ni plaintiff, which is either Quezon City, or residence ni defendant, which is either or pwede naman Manila. Second cause of action natin, recovery of real property, it is located at Pasig. So iba rin ang venue. Saan natin ngayon ipa-file yun? We can file it, diba, as long as one of the causes of action falls within the jurisdiction of the RTC. Doon natin ipa-file sa RTC. And respect of venue, provided that the venue also lies therein. Doon ba ang venue sa RTC? Yes, kasi doon ang venue nung recovery of real property. Okay? Are we clear? I hope it's intindihan. So let's answer. So first question, pwede ba niya i-join to? One-on-one. One plaintiff, one defendant. So it need not to comply with the rules on join there. Kahit na it does not arise from the same transaction or series of transaction. Specific performance, collection of 2.5 million, damages 3 million. So wala namang special civil action. Pwede ba niya i-join? Yes, pwede niya i-join. Okay, so pag ganyan yung mga tanong sa bar, make sure na i-lay down nyo yung rules for para ma-impress yung examiner. Lay down the rules, yung diniscuss natin. Not only by answering yes, it can be joined. Hindi siya ganun ka-impressive. Second question, P1, D1, D2, D3, jointly nangutang para magtayo ng negosyo, pwede ba? Since multiple parties to, it should comply with the rules on joinder. Meaning to say, it should comply with the rule that it should arise from the same transaction or series of transaction, or it involves common question of fact or law. Same transaction ba? Oh, of course. Kasi nga, jointly na nangutang sila. Okay, the obligation is joint. What about this one? Okay, magkakaiba ng multiple parties. Kailangan mag-comply siya sa rules on joinder. Meaning to say, it should arise from the same transaction. Hindi naman siya nag-arise. Same transaction. Di ba? Magkakaiba sila. Nangutang para pang paggawa ng bahay. Nangutang pambili ng kotse. Okay? So, hindi pwede i-join. Kasi it did not comply with the rules on joinder of parties. Sir, paano naman to? Hindi rin pwede i-join kasi it is a special civil action partition. So, it will violate yung third rule natin. Clear? Question. What, sir, if ito, matigas ang ulo ni P1, ginoin pa rin ni P1 in one complaint itong several causes of action? Okay? Ano ba ang rule natin? The rule is that if there is a misjoined causes of action, under the rules of court, the court should order the severance of the misjoined causes of action, motu proprio or via motion of any party. So in this case, kailangan si court motu proprio mag-order, paghiwa-hiwalay nyo yan kasi it will violate the rules on joinder of causes of action. Or kung nakalimutan ni judge, pwede either of the parties will file a motion to sever the misjoined causes of action. Are we clear? Question, sir, paano kung hindi nila nagawa yun? Nakalimutan ni judge na mag-order na i-sever, nakalimutan ng parties na misjoinder of causes of action pala, they forgot to file a motion to sever the misjoined causes of action. Nagkaroon ngayon ng judgment. Question, will that invalidate the judgment? Is the judgment void? Kasi ginoin niya sa isang complaint itong mga causes of action na yun. And this is a clear misjoinder. Misjoinder of causes of action. But hindi siya na-severe. Nagkaroon ng judgment. Is the judgment void? No, the judgment is not void. Bakit, sir? Because misjoinder of causes of action is only a procedural error. It is not a jurisdictional error. Okay? So, failure of the party or the parties to object will constitute as a waiver. Okay, are we clear? So, this is joinder of causes of action. Let's go to our slides. So I have said, joinder of causes of action. Take note, first rule, joinder of causes of action is not compulsory, but merely permissive. So pwede nyo paghiwa-hiwalayin, or pwede nyo naman i-join. Of course, sa actual, mas maganda hiwa-hiwalay. So conditions natin, para magkaroon ng proper joinder of causes of action, you should comply with the rules on permissive joinder of parties under Rule 3, Section 6. So, we will determine if it is one-on-one or multiple parties. Kasi, under, na-discuss naman natin kanina, it should arise from the same transaction or series of transactions para mag-comply sa rules on joinder of parties. Number 2, it shall not include special civil action or action governed by special rules, totality rule, maraming causes of action, but take note, all of them must be primarily for recovery of money. The aggregate amount shall be the test of jurisdiction. And yung respect of venue and jurisdiction na sinasabi ko, there are several causes of action, parehas ang parties, pero magkaiba, dahil maraming causes of action, iba-iba ang kanilang venue and jurisdiction. Now, what is the legal effect of misjoinder of causes of action? Meaning to say, class, we have a violation of any of those rules. Kaya magkakaroon ng misjoinder. When is there a misjoinder? Yun nga. Is it a ground for dismissal? Kung merong violation of any of the rules that we have discussed, can the court, motu proprio, dismiss the case because of a misjoinder of causes of action? No, it is, first of all, it is not a ground for motu proprio dismissal. Ano ba yung mga motu proprio dismissal natin? Lack of jurisdiction over the subject matter, litispendentia, res judicata, prescription. Hindi naman kasama yung misjoinder of causes of action. So, the court cannot motu proprio dismiss it pag misjoinder yung causes of action. And secondly, meron tayong remedy in case of a misjoinder or non-joinder of parties. Yung at any stage of the proceedings, ba't ko yan nilagay, class? Kasi pag yung at any stage of the proceedings, this pertains to non-joinder of parties. Kasi at any stage of the proceedings, a party can be added or dropped upon motion of either party by the court motu proprio. So, pag misjoinder of causes of action naman, ang keyword natin dyan, severance. Paghihiwalayin natin yung misjoined causes of action. Remedy in case of misjoined causes of action, severed under Rule 2, Section 6. If there is a misjoined causes of action, the court should order the severance of the misjoined causes of action, motu proprio or pwedeng via motion of any of the parties. If misjoined causes of action were not severed and the court rendered judgment, is a judgment void, as we have discussed, as enunciated by the Supreme Court in the case of Adam versus Elon, it will not render the judgment void because misjoinder of causes of action is only a procedural error. It is not a jurisdictional error. Failure to object will constitute as a waiver. Misjoinder of causes of action, misjoinder of parties, diniscuss na natin, magkaiba sila. But in order to have a proper joinder of causes of action, you should comply with the rules on joinder of parties, permissive joinder of parties. Oops, ito hindi natin na-discuss. So, I want to distinguish the following. Failure to state a cause of action, lack of cause of action, no, lack of legal capacity to sue, and lack of legal personality to sue. Ano ba ang difference niyan? First of all, failure to state a cause of action. Let's go to yung number 1. Failure to state a cause of action. As I have said kanina, there is an absence of any of the requisites of the cause of a cause of action. Yung complaint ni plaintiff, wala siyang naka-allege na right on his part, or wala siyang naka-allege na obligation on the part of the defendant, or walang naka-allege na breach. For example, it is a collection of sum of money. The plaintiff forgot to state therein that there was a demand. Okay? In such case, it will be prone to a dismissal, probably a dismissal because of failure to state a cause of action. Okay? So, failure to state a cause of action may absent na requisite ng cause of action. Failure to state a cause of action, the term of this is the failure to state a cause of action is under Rule 8, Section 12 of the Rules of Court. Okay? What is the basis in order for the court to determine whether or not there is a failure to state a cause of action? The basis of which is the complaint of the plaintiff. Okay? What about lack of cause of action? Lack of cause of action is also known as a demurrer to evidence under Rule 33. Ano ang ground niya? Under the facts and the law, the plaintiff is not entitled to relief. Ano ang basis niya ng lack of cause of action? Also known as demurrer to evidence. Ang basis niya, hindi yung complaint. It's not the complaint of the plaintiff. The basis of which is or are the evidences presented by the plaintiff during the trial. So medyo malayo-layo na tong lack of cause of action na fina-file. This is a motion to dismiss, also known as demurrer to evidence, on the ground of under the facts and the law, the plaintiff is not entitled to relief. Okay? So what about lack of legal capacity to sue or no legal capacity to sue? It is also a ground as an affirmative defense under Rule 8, Section 12. So there is no legal capacity to sue if the party suing, yung nag-file ng kaso, is not a natural person, or is not a juridical person, or is not an entity authorized by law to sue. So in such case, the defendant may file an answer with an affirmative defense of lack of legal capacity to sue. What about lack of legal personality to sue? Lack of legal personality to sue, okay, the party suing or the party who filed, the plaintiff who filed the case, is not a real party in interest. Kaya wala siyang legal personality to sue. And of course, this also means that there is a failure to state a cause of action. Yung lack of legal personality to sue is also a failure to state a cause of action. Pero yung pag sinabi mong lack of legal personality to sue, hindi real party in interest si plaintiff. He is not the party who stands to be benefited or injured by the judgment. And also, si plaintiff does not own the right. Kaya ka magpa-file ng lack of legal personality to sue. What is the basis of lack of legal personality to sue and lack of legal capacity to sue? Also, the complaint of the plaintiff. So, the allegations in the complaint, doon natin madedetermine kung may lack of legal personality to sue or kung merong lack of legal capacity to sue. Okay? Unlike lack of cause of action, or motion to dismiss on the ground of under the facts and the law, the plaintiff is not entitled to relief. Ang basis natin yan, as I have said, malayo na during the trial because it can be filed after the plaintiff has rested his case. What about splitting a single cause of action under Rule 2, Section 4? When is there a splitting a single cause of action? So to illustrate, madali lang yan. Meron kang main relief and then hiniwalay mo yung main relief with the incidental relief. What is a good example? Let's say you have a debt of, let's say merong utang si defendant na 10 million pesos. So the plaintiff creditor filed a collection of 10 million pesos before RTC Branch 1 Manila. Then he forgot to include therein, hindi ko nga pala nasama yung interest, ano pa, yung attorney's fees. Okay? Because dahil sa kanya, nag-file tuloy ako ng kaso, so wala ring attorney's fees. Anong ginawa niya? He filed another complaint kahit na in the same case or to a different court. He filed for the interest and attorney's fees. Okay? Originating from the 10 million debt So in that case, there is splitting a single cause of action. Because in-split niya yung main relief, which is 10 million, with the incidental relief. Incidental relief niya are the attorney's fees and damages arising from the debt. So that is splitting a single cause of action. Take note of the case of Central Visayas Finance Corporation versus Spouses Adlawan. Why? In that case, may debt secured by a mortgage. So hindi nakapagbayad ng utang. Question, can the plaintiff file an action to recover the debt and at the same time file an action to foreclose the mortgage? Pwede ba gawin ni plaintiff yun? No, because in such case, it is splitting a single cause of action. Okay? We only have one cause of action, which is the non-payment of debt. But we have two options to recover it. It's either recovering the debt itself or foreclosing the mortgage. Kaya, you cannot file it separately. The creditor cannot split his single cause of action by filing a complaint on the loan, yung collection of sum of money, and thereafter, a separate complaint for foreclosure of the mortgage. There is only one cause of action, but with two methods of collecting. So, what are the three modes of committing forum shopping? First is litis pendentia. Number 2 is res judicata, and number 3, splitting a single cause of action, which can either be litis pendentia or res judicata. What is the difference? When we talk about litis pendentia, you filed a case, then you file another case involving the same parties and same cause of action. The first case is still pending. So, that is litis pendentia. On the other hand, if you talk about res judicata, you filed the first case, then you filed another case. Before filing that second case, the first case was already dismissed. Final and executory judgment was the first case. And then you again filed another case involving the same parties and same cause of action. So that is res judicata. What about, sir, yung splitting a single cause of action, which is either litis pendentia or res judicata? Yun yung first example ko kanina. If you will split the main relief with its incidental reliefs. Now, let's go to jurisdiction. So, your complaint, you already have a cause of action. You should know saang court ko ifa-file to. So, we should be familiar with RA 11576. So, basically, ang jurisdictional amount natin ngayon under the present rules is 2 million pesos and 400,000. Yung 2 million pesos, if the action involves personal property or collection of money. On the other hand, if the jurisdictional amount is 400,000, if that would be the basis, if it does not exceed 400,000, it will belong to the jurisdiction is within the MTC if it is a real action. Meaning to say, if the action involves Title 2, possession of real property or any interest therein. So if it is 400,000 and 1 peso above, the filing of the case, if it is a real action, is with the RTC. So first rule. So jurisdiction, we have 4 aspects of jurisdiction. Jurisdiction over the subject matter, which is conferred by law. We have jurisdiction over the parties, wherein the court will acquire jurisdiction over the plaintiff upon filing of the case or of the complaint. And not only that, of course, there must be payment of appropriate docket fees. On the other hand, the court will acquire jurisdiction over the person of the defendant upon proper service of summons. Or, kahit walang proper service of summons, if there is a voluntary appearance on the part of the defendant. Okay? Third aspect of jurisdiction, jurisdiction over the issues. Okay? When does the court acquire jurisdiction over the issues of the case? Pag nag-file ba ng complaint si plaintiff, naka-allege doon si defendant has a debt of 5 million. Will the court acquire jurisdiction over the issue of the case, which is 5 million? No. Why? Because in order to have jurisdiction over the issues, there must be an allegation, and there must be a denial. Meaning to say, there must be an answer on the part of the defendant. And not only that, that answer should have a specific denial. Okay, so in that case, there will be a jurisdiction over the issue. And the last aspect of jurisdiction is jurisdiction over the rest. Custodial legis, you already know that. So let's go specifically to jurisdiction over the subject matter. As I have said, it is conferred by law, by BP 129, RA 7691, and yung bago natin ngayon, RA 11576. Second rule natin, jurisdiction over the subject matter is determined by the material allegations in the complaint. Okay? So what determines jurisdiction are the allegations stated in the complaint. Like for example, si plaintiff alleges in his complaint that the defendant owes him, let's say, 2.5 million. But in truth and in fact, the debt was really only 2 million. Pero since he wanted to file it before the RTC, he made it appear that the debt was 2.5 million. So that was being alleged in his complaint. Then he filed it to court. Here comes the defendant, denied specifically allegation. Then not only that, the defendant presented in his answer yung original promissory note which contains that the debt was only 2 million. Not only that, let's say there was a CCTV during the time that the debtor, that the creditor or the plaintiff was signing the promissory note. Let's say kita sa CCTV, it was only 2 million. And not only that, the judge knew personally the plaintiff. Kasi plaintiff talagang sinungaling at magnanakaw. Okay, so during the trial, the judge, dahil alam ni judge that jurisdiction over the subject matter is a motu proprio dismissal. Okay, it is a ground for motu proprio dismissal. Because of that, because of the evidences in the answer of the defendant, because during the trial, it was proven that it was only 2 million. And RTC siya. Sabi na MTC to eh. So, the RTC judge dismiss it outrightly. Is the judge correct? No. Why? Because basic is the rule that jurisdiction over the subject matter is determined by the material allegations in the complaint. And also, we can apply the rule on yung tinatawag natin na if the jurisdiction is determined by the material allegations in the complaint, the jurisdiction will stay until final judgment. Okay? So, here are the basic rules. Yung conferred by law, BP 129, RA 7691, and yung bagong 11576, 2 million for 100,000. If the claim is recovery of personal property or money claim, and the amount is exactly 2 million, it will belong to the jurisdiction of the MTC. Why? Verbal legis, because since the law is clear that if it does not exceed 2 million or if it does not exceed 400,000, if it is a real property, it will the jurisdiction will belong to the first level court. Okay, so pag eksakto, first level court. RTC's jurisdiction, ano bang importante dyan? Incapable of pecuniary estimation. Okay? So, if the question in the bar exam is about the jurisdiction of the RTC, more particularly with incapable of pecuniary estimation, don't forget to apply the primary objective test. Okay? Sir, what is the primary objective test? To determine if an action is incapable of pecuniary estimation, okay, the criterion is to first ascertain the nature of the principal action or the remedy sought. What is the meaning of that? If, for example, the action that was filed is annulment of a sale involving a real property worth 350,000. Annulment of a contract of sale of a real property with an assessed value of 350,000. Where will you file it? What court has jurisdiction? So, nakita nyo, 350,000. So, it involves real property. In under 11576, if it is if it does not exceed 400,000 MTC, so MTC will have jurisdiction. Wrong. Why? Because applying the primary objective test, okay, since the cause of action is annulment of contract of a sale of a real property, magkano yung assessed value? 350,000. Yung primary objective test or the principal action or the remedy sought is to annul the contract. Okay? Therefore, the cause of action is whether or not the plaintiff has the right to annul the contract. Meaning to say, the realty in this case is only incidental. Okay, so pag medyo ganun, hindi clear kung ano ba to, does it involve real action para mag-fall siya sa 400,000 below, 400,000 above, or baka RTC naman siya, or collection of sum of money, 2 million. Just always apply the primary objective test. Okay? See what is the main relief of the plaintiff. But other than that, I would like you to take note of the following causes of action. Why? Because in the following causes of action, the basis of the jurisdictional amount is the assessed value of the property. Okay? Ano-ano po yung apat, sir? Number 1, action reinvindicatoria. Number 2, action publicana. By the way, what is action publicana? Action publicana, we can also call it as a delayed filing of an ejectment case. Because after the demand, naglapse yung 1 year, then you want to recover the possession of the property, your proper cause of action is action publicana. Okay? And if the action is, and if your cause of action is action publicana, in order to determine jurisdiction, determine the assessed value. Okay? Number 2, take note of the action reivindicatoria. Okay? Ang basis natin dyan in determining the jurisdictional amount is also the assessed value. What is action reivindicatoria? If you want to recover the possession and ownership of the real property. Okay, what else? Quieting of title. Okay? Ang basis natin dyan is the assessed value of the property. And the last one is yung partition. Okay? Ang basis natin dyan to determine the jurisdiction of the court is the assessed value. But if the cause of action is about annulment of a contract, applying the primary objective test, the cause of action is whether or not you have the right to annul. So it is incapable of pecuniary estimation. Next, of course, yung mga RTC's special jurisdiction sa family court, environmental court, commercial court. MTC naman, ano yung mga jurisdiction ng MTC? So I cannot discuss each and every special jurisdiction of RTC and MTC kasi hahaba pa. Marami pa tayo i-discuss. So overview, ano ba yung mga jurisdiction ng MTC? Ordinary procedure, alam natin niya, 400 below, 2 million below. Summary procedure, small claims, ejectment cases, take note, regardless of the amount of back rentals. And of course, the delegated jurisdiction of the MTC. What is the importance of that? If the case is about an agrarian case or land registration case, what is the significance of that? In case you will have an adverse judgment before the MTC and the judgment was rendered by the MTC in the exercise of its delegated jurisdiction. In such case, the appeal is not going to the RTC. You can go directly to the Court of Appeals. Why? Because since it is an agrarian case or a land registration case, cadastral case, okay, it is a delegated jurisdiction. Meaning to say, in soul, it was really decided by the RTC. But in body, it was only decided by the MTC. So in case of an adverse judgment, okay, the appeal is to the Court of Appeals directly, which we will discuss later about appeals. Okay, this one, alam nyo na yan. Jurisdiction is different from exercise of jurisdiction. Jurisdiction is the authority of the court to decide, to hear, and to execute its decision. Okay? Where there is jurisdiction over the person and subject matter, yung decision on all other questions arising in the case is what we call the exercise of jurisdiction. Okay? So if you will file a case, let's say before the RTC, and that case is, let's say, within the jurisdiction of a commercial court, which we have discussed, commercial court sa RTC ngayon yan, di ba? There is an RTC which was kumbaga designated by the Supreme Court to be a commercial court. If let's say the action is about a commercial court jurisdiction, but it was filed in an RTC which have an ordinary procedure lang yung hawak niya, not a special court. It is not a special commercial court. Okay? The RTC, yung na hindi commercial court, cannot dismiss the case motu proprio on the ground that it has no jurisdiction. May jurisdiction ng RTC. RTC yan but it has no power to exercise jurisdiction. So in such case, kailangan ibigay niya sa RTC na commercial court which has the power to have an exercise of jurisdiction over commercial cases. And take note, errors which the court may commit in the exercise of jurisdiction are merely errors of judgment, which are proper subject of an appeal. Yung second rule natin, determined by the material allegations of the complaint, as we have discussed. It is the material allegations in the complaint that controls, okay, rather than the caption or the title that title of the case being given. What is a good example of that? Let's say, title nung complaint mo is ejectment, unlawful detainer. Okay? But your allegations in your complaint is to pay back rentals or to vacate. Take note or to vacate. Yung sa example natin end. Or to vacate. And you filed it before the MTC. Do you think the MTC can dismiss the case motu proprio on the ground of a lack of jurisdiction over the subject matter? Take note, what is the title of your complaint? Ejectment, unlawful detainer. But your allegations is to pay back rentals of 3 million pesos or to vacate. Can the MTC dismiss it motu proprio? Yes. Sir, bakit ganun ejectment nga? MTC naman. Because basic is the rule that the material allegations in the complaint controls rather than the caption. So kung or yan, collection of back rentals of, magkano ba yung sinabi ko? 9 million ba? Anyway, more than the jurisdiction of the MTC. Or to vacate. Vacate is action for specific performance. Then, the jurisdiction belongs to the RTC. But if it is the other way around, pinail mo sa RTC. Let's say, ang title mo is to pay back rentals of 10 million and vacate. Yun yung allegations mo. Okay? Pinail mo sa RTC. Can the RTC dismiss it motu proprio? Yes, because that cause of action is a cause of action of ejectment. Now, this doctrine of adherence of jurisdiction. Yun yung example natin. Yung example ko kanina. If the complaint alleges the claim of 1.5 million, during the trial, what was proven was 2.5 million. And let's say it was filed before the MTC. Okay? Ano yung nakalagay sa complaint ni plaintiff? 1.5 million. Collection of 1.5 million. During the trial, ang napatunayan, dahil magaling yung abogado ni defendant, 2.5 million talaga ang utang. Anong sabi ni MTC judge? Dismiss ko to motu proprio. The judge, MTC judge correct? No. The MTC judge is not correct. Sir, 2.5 million yung napatunayan ng trial. Even though, why? Because of this doctrine of adherence of jurisdiction. Okay? Once vested by the allegations in the complaint, jurisdiction also remains vested irrespective whether or not the plaintiff is entitled to recover upon all or some of the claims asserted therein. Okay? So once the jurisdiction has attached, why? Because of the allegations in the complaint, it will remain in such court until judgment. So that is the doctrine of adherence of jurisdiction. Basic, next rule natin sa jurisdiction over the subject matter, it can be raised anytime, even during appeal. Of course, the case of Tiham versus Sebong Hanoy. Okay? Hierarchy of courts. We're talking about jurisdiction over the subject matter. This hierarchy of courts will only come into the picture if there is concurrence of jurisdiction or concurrent jurisdiction. Like for example, in a petition for certiorari, prohibition, and mandamus, RTC, CA, Supreme Court, meron silang concurrent jurisdiction. Right? So, doon lang papasok yung principle ng hierarchy of courts. Okay? Why? What is this hierarchy of courts? Although the SC, CA, RTC have concurrent original jurisdiction over petition for certiorari, prohibition, mandamus, kawaranto, parties are directed as a rule to file their petition before a lower rank court. So punta ka muna sa RTC, okay? Or sa CA. Huwag ka dumiretso sa Supreme Court. But what are those instances wherein the Supreme Court will take cognizance of the case? Even though pwede naman siya i-file muna sa RTC. Number 1, if it involves issues of constitutionality. Number 2, if the issue, ito yung lagi, kaya napupunta lagi sa Supreme Court, yung petition for certiorari, even though hindi siya nagdaan sa RTC or CA. If the issue involved are of transcendental importance. What else? If the case is of first impression. Number 4, constitutional issues raised are better decided by the court. Exigency in certain issues, petition for review, the act of a constitutional organ. Okay? Petition for review of what? Of an act of a constitutional organ. And if claim had no other plain, speedy, and adequate remedy. Another one, as held in the case of Gio Samar, if the petition includes questions that are dictated by public welfare and advancement of public policy. Okay, let's go to the second topic. So remember, we're talking about the first stage of civil procedure. I'm telling you, I'm discussing the story of civil procedure. Nasa complaint pa rin tayo. We're done with. You should have a cause of action. You should know what court that has jurisdiction over your case. Let's go to venue. Of course, if we talk about venue, simple as just knowing whether if it is a personal action or a real action. Why? Because if it is a real action, if it is an action that involves Title II, possession of real property or any interest therein, it is a real action. Therefore, the venue must be filed in courts where the property is geographically located. If it is a personal action, meaning to say, it is not an action which involves Title II, possession of real property or any interest therein. Saan ang venue? Residence of the plaintiff or residence of the defendant at the option of the plaintiff. And another important topic in venue is the stipulation as to exclusivity of the venue. Okay? Basic requirements, kailangan kung meron kayong exclusive stipulation, number 1, it must be written. Number 2, it must be made after or before the filing of the case. And number 3, the most important, there must be words of exclusivity. Okay, let's go to venue, slides. Venue distinguished from jurisdiction, very important. Venue is procedural. Failure to object will constitute as a waiver. jurisdictional error, it cannot be waived. This is very, what is a good illustration of this? Let's say, plaintiff filed an action for ejectment. The property is located at Pasig. The plaintiff is a resident of Quezon City. The defendant is a resident of Manila. Okay? So, umuupa although ang residence ni defendant ay sa Manila, meron siyang inuupahan na property, a plaintiff, which is located at Pasig. Okay? Because of failure to comply with the condition of the lease, or because of failure to pay rentals, okay, or because of the expiration of the contract of lease, plaintiff filed an action for ejectment. Okay? Saan niya final yung action for ejectment? Final niya yung action for ejectment sa MTC Quezon City. Okay? Residence ni plaintiff, Quezon City. Residence ni defendant, Manila. Yung property na nililease ni defendant is located at Pasig. So, saan final ni plaintiff ejectment? Final niya sa MTC Quezon City. Sabi ni judge, oops, lack of jurisdiction over the subject matter. I will dismiss it motu proprio. So, sa MTC judge, dinismiss niya motu proprio on the ground of lack of jurisdiction over the subject matter. Is the judge correct? No, because venue is different from jurisdiction. Take note, in ejectment cases, it is the MTC who has jurisdiction. MTC to may jurisdiction naman siya. What is wrong is the venue. Because the venue should be where the property is located. In this case, Pasig. Okay, so it is wrong for the court to dismiss it motu proprio on the ground of lack of jurisdiction over the subject matter, because venue is not the same with jurisdiction, and jurisdiction is not the same with venue. Venue on personal action, we already discussed. Take note that personal action is different from in personam. Okay? Basic distinction. Personal action, this is important for purposes of determining the venue or even the jurisdiction. Diba? This sa venue, residence ni plaintiff or residence ni defendant. So, yun yung significance of personal action. On the other hand, if we talk about in personam, this is important for purposes of determining the service of summons. Okay? Kasi pag in personam siya, okay, there is a designated plaintiff and there's a designated defendant, and the plaintiff wants that particular defendant to be particularly liable. That is an action in personam. So magkaiba ang personal action sa in personam. Real action, we already discussed kung saan ang venue. But take note, not every action involving real property is a real action. Kasi sometimes, realty may only be incidental. Like what I have said, take note of the primary objective test. Okay? Ano ba yung primary objective test? In my example, nagre-rent si Leslie nung bahay ni lessor. And since si Leslie is involved in factory, yung nagtatago siya ng mga bulk goods, anong ginawa ni Leslie? Sinira niya yung loob ng house na nire-rent niya kay lessor. So, nung nasira, nakita ni lessor, mamahalin yung paggawa niya ng loob ng bahay, yung design. The lessor filed an action for damages worth 5 million pesos. Damages to what? To that real property. Okay? So, when the lessor filed an action for damages worth 5 million pesos, damages of that real property, where is the venue? Is it in the place where the property is located, or residence of the plaintiff or the defendant? Residence of the plaintiff or the defendant at the option of the plaintiff. Why? Because applying the primary objective test, even though it involves a real property, the issue is not the real property. Okay? The primary objective, the relief sought by the plaintiff here is to have damages. So, in this case, the realty is only incidental. So, So in an action for specific performance to deliver title or deliver a notarized deed of sale of a real property, is it automatic that the venue, if ito yung cause of action mo, action for specific performance to deliver a notarized deed of sale, does it mean that the venue is automatically where the property is located? So it will depend if the property was already delivered. Let's say for example, Mr. Seller, binenta niya kanyang real property kay buyer worth 10 million, and then nagpirmahan na sila ng kontrata. Sabi ni buyer, sige seller, pwede ka na tumira dito sa bahay, pero yung deed of sale, papagawa ko pa eh. Okay? After 1 month, bibigay ko sa yung deed of sale. Okay? Tapos yung isang buwan, hinihingi ni seller yung deed of sale para pa-register na niya sa pangalan niya. Ayaw ibigay ni buyer, ni seller. Ayaw ibigay ni seller yung deed of sale kay buyer. So hinihingi na ni buyer yung physical document, yung notarized deed of sale. Ayaw ibigay ni seller. So anong ginawa ngayon ni buyer? Nag-file siya ng action for specific performance to deliver the notarized deed of sale. Okay? Saan ngayon ang venue? Meaning to say, will we follow the rule that if it is a real property, the venue is where the property is located? Or should we apply the rules on personal action, wherein we can file it in the residence of the plaintiff or the defendant? So ano ngayon ang technique natin? Determine who is the ownership. Determine if the ownership was already transferred. Okay? Like in my example, since under the law on sales, delivery of the property will constitute as a transfer of ownership. In this case, the buyer is already the owner of the property. So in that case, the cause of action of specific performance to deliver the notarized deed of sale will be a specific performance. Okay, specific performance. Therefore, being a specific performance, it is a personal action. Therefore, the venue is in the residence of the plaintiff or residence of the defendant. Okay? But if we will change the facts, okay, nag-enter sila ng contract of sale of real property, hindi pa dinideliver yung real property kay buyer, hindi pa tumitira si buyer dun sa real property, nagbayad na si buyer, nag-file ngayon si buyer ng action for specific performance to deliver the notarized deed of sale. Okay, in that case, that will be considered as a real action. Therefore, the filing is in the place where the property is located. Bakit, sir? Because in that case, applying the primary objective test, you are, in effect, you want to recover the real property. Okay, because in my second example, the buyer is not yet the owner kasi hindi pa na-deliver sa kanya yung property. So yung cause of action, specific performance to deliver the notarized deed of sale will constitute as a specific performance to deliver a real property and not only the physical deed of sale. Next. Yun na pala. If the primary objective of the action is to acquire or possess the real property, like in my second example, hindi pa na-deliver kay buyer, yung action for specific performance to deliver the notarized deed of sale will be a real action. But if there was already delivery, yung ownership and possession na kay buyer na of the real property, then it will become as a personal action. Okay? Stipulation as to venue, we have discussed. Written, it must be made before filing of the complaint. Number 3, there must be words of exclusivity. Ano yung mga words of exclusivity natin? Kasi pag ang nilagay natin doon sa contract, in case of legal dispute, the filing or the venue will be at Quezon City, period. Okay? And then si plaintiff, taga Manila. Si defendant, taga Pasig. Pwede ba ang venue sa Pasig? Yes, pwede. Sa Manila? Yes, pwede. Why? Because there is no word of exclusivity. So, kailangan ilagay natin itong mga to. Number 1, kailangan may exclusively sa Pasig or solely sa venue sa Pasig, exclusive in this court. But take note, that court does not pertain to jurisdiction because jurisdiction cannot be a subject of stipulation. Okay? Exclusive in courts of Manila, exclusive in courts of Pasig. Okay? Particularly in courts of Pasig. So pag wala yung mga qualifying words na yan, it will be considered as an additional forum only. What about this Briones Doctrine? Okay? The cause of action is action to annul the contract of sale. Action to annul a contract. Any contract. Okay? If, for example, the plaintiff is from Quezon City, the defendant is from Manila, and in their contract of sale, okay, it is stipulated that in case of legal dispute, the venue shall be in Pasig only. Okay? Anong ginawa? Nagkaroon ngayon ng breach. Anong ginawa ngayon ni buyer? Ang venue ginamit niya ay Quezon City or Manila. Take note, yung contract nila may words of exclusivity. Hindi niya pinail sa venue sa Pasig. Is that improper venue? Si defendant nag-file ng answer with an affirmative defense of improper venue under Rule 8, Section 12. Will that affirmative defense be granted? No. Why? Because of the Briones Doctrine. If the cause of action is to annul the contract, and then of course, you should not be bound by such contract kasi ina-assume mo nga yung validity ng contract. Okay? So you are not bound by the exclusive venue stipulated therein. A complaint directly assailing the validity of a written instrument should not be bound by the exclusive venue stipulated therein. Let's go to parties. Okay? Parties who may be parties in a civil action. Of course, natural person, juridical person, an entity authorized by law to sue. What is the significance? Pag hindi ka nag-fall doon, pwede mag-file si defendant ng answer with an affirmative defense of lack of legal capacity to sue. Not failure to state a cause of action. Not lack of cause of action. But lack of legal capacity to sue. Kasi kahit na may cause of action ka, pero kung wala ka namang capacity to sue, kasi corporation ka na hindi naman registered sa SEC or minor ka, you have no legal capacity to sue. Kahit na ikaw yung real party in interest. Who is a real party in interest? Just memorize, he is a party who stands to be benefited or injured by the decision. Not only that, how will we determine if the party is the one who will stand to be benefited or injured? Ano ang technique namin sa class? If it is in so far as to the plaintiff, he is a real party in interest if he owns the right. In so far as to the defendant is concerned, he is a real party in interest as to the defendant if he is the one who has the obligation. Okay? Example, si creditor, pinautang si debtor, 10 million, due and demandable kahapon, hindi nagbayad, nagbigay ng demand letter si creditor, hindi pa rin nagbayad si debtor. Si debtor, alam ni creditor na wala ng pera, sino ang finailan ni creditor? Yung mayamang magulang ni debtor. Okay? So, it is a clear example of failure to state a cause of action. Why? Because of an absence of an obligation. Because the parent of the debtor is not the one who has an obligation to the creditor. Okay? Rule natin. Siyempre, of course, you should implead a real party in interest. The legal effect, if you will not implead a real party in interest, is that the plaintiff, pag nag-file siya ng complaint against the defendant who is not a real party in interest, the defendant may file an answer with an affirmative defense of failure to state a cause of action under Rule 8, Section 12. What is the basis? The complaint of the plaintiff. Next. Indispensable party. Real party in interest ba ang indispensable party? Yes. Siya nga ang totoo na real party in interest. That's why if you will be asked to define who is a real party in interest, so if you will be asked to define an indispensable party, he is the party, he is a real party in interest without whom no final determination can be had. Indispensable party, ang tunay na real party in interest without whom no final determination can be had. Anong example? An example of which is a co-owner. Diba? Maraming co-owner yan. Pag yung isa nag-file ng partition, hindi niya in-implead yung isang kapatid niya kasi for whatever reason, he needs to implead yung co-owner na yun. Okay? Now, what is the rule? If you fail to implead an indispensable party. Okay? So, there will be no final valid judgment. So, what is the legal implication of that? Can the court dismiss the case motu proprio? Kasi indispensable party yan. Bakit hindi mo in-implead? So, dinismiss ni court motu proprio. Is the court correct? No. Why? Because failure to implead an indispensable party is not a ground for motu proprio dismissal. And as we have discussed kanina sa cause of action sa joinder of parties, meron tayong remedy kasi. At any stage of the proceedings, a party can be added or dropped upon order of the court, motu proprio, or upon motion. So in this case, pag hindi na-implead yung isang co-owner sa action for partition, okay, si court dapat mag-order, i-implead mo yung isang co-owner mo. Or kung hindi napansin ni court, si party mag-file ng motion to implead that indispensable party so that the court may issue an order ordering the plaintiff to implead such indispensable party. Sir, what if nag-issue na ng order si court ordering the plaintiff to implead the indispensable party, hindi pa rin in-implead ni plaintiff, can the court dismiss the complaint? Yes, but not on the ground of failure to implead an indispensable party kasi wala ngang ganong ground, but on the ground of Rule 17, Section 3. Okay? Dismissal of the case due to the fault of the plaintiff. Alin doon? Under Rule 17, Section 3, the case can be dismissed motu proprio or upon motion. Okay? Or upon motion of the defendant on the following grounds. Number 1, if the plaintiff fails to be present at the date of his presentation of his evidence in chief. Number 2, if the plaintiff fails to prosecute within unreasonable length of time. Number 3, failure to comply with the rules of court. And number 4, failure to comply with the lawful order of the court. So that will be the ground why is it that the case will be dismissed due to the refusal of the plaintiff to implead such indispensable party. Okay? Failure to comply with the lawful order of the court. Nag-issue na ng order si judge, impede mo yung indispensable party, ayaw mo pa rin sumunod. In that case, the case can be dismissed. Okay, next. Necessary party. Definition. First question, real party in interest ba si necessary party? Of course, real party in interest yan. He is a party that will be benefited or injured by the decision. Okay, but he is not an indispensable party. Kasi kahit na wala yung isang necessary party, we can have a final judgment, a valid final judgment. So sir, if this will be asked in the bar exam, define who is a necessary party. So a necessary party is a real party in interest, but not an indispensable party, but who is ought to be impleaded in order to have a complete relief. Okay, para makumpleto lang yung utang natin, for example, kay plaintiff, kailangan i-implead niya lahat ng necessary party. What is a good example? Sayang, nabura ko na. Pag si plaintiff, nangutang sa kanya si defendant 1, defendant 2, defendant 3, jointly, because magtatayo ng negosyo si defendant 1, 2, and 3. Okay? So, naging joint demandable after sending a demand letter, di pa rin nagbayad. Ang finailan lang niya ng collection is si defendant 1 and defendant 2. Okay? Ang utang is 3 million. Therefore, tagwa 1 million sila. Hindi niya in-implead si defendant 3. Can the court dismiss the case motu proprio for refusal to implead defendant 3 as a necessary party? No. Why? Kasi nga, indispensable party nga. Pag hindi mo in-implead, the court cannot dismiss it motu proprio. Ito pa kaya necessary party. Another reason, kasi nga, as we have discussed, at any stage of the proceedings, a party can be added or dropped upon order of the court, motu proprio, or by motion of any party. Okay? So, pag nag-issue si court ng order, impleading the necessary party, okay, what if, for example pala, what is the duty of the plaintiff if ayaw niya i-impede yung isang necessary party? Under the rules of court, he shall set forth the name of the necessary party. And number 2, the reason. Why is it that the plaintiff doesn't want to impede such necessary party? Why? Because if the reason is meritorious, let's say, for example, it was already condoned by the plaintiff, kaya it was already paid by the defendant, then the court will not issue an order asking the plaintiff to implead the necessary party. But if the reason is unmeritorious, the court may order or should order the plaintiff to include the necessary party. What if the plaintiff still refuse to implead the necessary party despite the order of the court? Pwede ba siya mag-fall sa Rule 17, Section 3, motu proprio dismissal because of the fault of the plaintiff, failure to comply with the lawful order of the court? No. Because in this case, this is a necessary party, merong legal implication provided under the rules of court if you did not implead the necessary party. And the legal implication, if you did not implead the necessary party, despite the order of the court, is that the plaintiff will waive his claim against such necessary party who was not impleaded. Okay? So, hindi pwede i-dismiss pag yung necessary party lang ang ayaw i-implead ni plaintiff. Another important topic sa party, si class suit. Okay? Don't forget lang yung first requisite ng class suit kasi yun naman yung usual na absent every time there's a question in a class suit. Sir, what is that requisite? Okay, pakikabisado. There must be commonality or generality of interest over the subject matter. Okay, yun naman lagi yung wala kasi yung next requisite that the parties must be so numerous that it would be impracticable for all of them to be impeded. Hindi naman usually tinatanong yon, pero isama nyo na rin pag tinanong yung class suit, sufficient representative. Let's focus on sa first requisite. Sir, what is the meaning of that commonality or generality of interest over the subject matter? Kasi baka mamaya tanong sa bar, merong owner, yung mga owners na, ano ba usual example ko dyan? Siyempre yung SUA, Sudden Unintended Acceleration, ng Montero. Okay? So maraming mga owners sa Montero who were victims of SUA. So, umarangkada bigla yung sasakyan nila, nabangga, na total wreck, may nabangga, maraming aksidente. So, mayroong one lawyer who was interviewed who is also a Montero owner. So, he was asked, so what is your legal step? Sabi niya, he will file a class suit for damages against Mitsubishi because of the SUA. So, I said to myself, of course, that class suit for damages will not prosper. Sir, why? Pare-parehas naman sila, hundreds naman sila. Okay, lahat naman sila na damage because of the SUA. Umandar bigla yung Montero. Okay? There is commonality of issue. But interest over the issue, they have individual, there is a distinction among them. What do you mean, sir? Lahat sila na damage because of the SUA, but the damages are not the same. So they should prove it individually, not as a class suit. Why? Because some are victims ng SUA na total wreck, some na natanggal lang yung bumper, some na nagasgasan lang. So, magkakaiba sila ng damages. So, they don't have common or general interest over the damages. And of course, ano yung classic example wherein class suit, prosper yung class suit? The case of Oposa versus Pactoran, which was written and decided by Chief Justice Hilario Davide. Ano ba yung cause of action doon? It's not about damages. Hindi naman sila nanghingi ng damages. The cause of action is yung ating intergenerational responsibility to a balanced and helpful ecology. So lahat tayo, we have interest over the destruction of the environment. Okay, lahat tayo, hindi natin mapaghihiwalay. It is not determinable yung interest natin sa kalikasan. So we can file a class suit for the destruction of the environment. Okay? So in short, basta may question sa class suit, please lay down, of course, the requisites, and don't forget the commonality or generality of interest over the subject matter.
Walang natira video. Pag may natirang mitigating circumstance minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natirang medium period, pag may natirang mitigating circumstance, minimum period. So, ganun lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang epekto, maximum period. Offset rule, i-offset mo muna. Tingnan mo kung ano yung remaining modifying circumstance. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1, section.
So, of course, my friends, you have, of course, a reply. To make it simple, a reply is an answer to an answer. Ayan. And the purpose of the reply is to transverse new matters raised in the answer. Transverse, dispute, di ba? Contest, transverse, new matters raised in the answer. But even though you fail to file a reply, under the new rules, no? If you fail to file a reply, okay lang. Kasi exceptional situation lang. Ang rule na ngayon, all new matters alleged in the answer are been controverted already. So, maski walang reply, all matters raised in the answer are being controverted already. If you talk...
In relation to dation in payment, the answer is yes, because the debtor would offer another thing. Example, if the thing to be delivered is a sum of money like 20,000, the debtor instead would offer his carabao in payment of his debt, and therefore the consent of the creditors is absolutely necessary. Okay? He may not want the carabao. Okay? But in application of payments, is the consent of the creditor required? Definitely, there is no question because he would accept. Okay, then there is consent. However, okay, the question that would have to be answered is to which debt the payment should be applied. The third
Together, we can.
natira, medium period. Pag may natirang mitigating circumstance, minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natirang medium period, pag may natirang mitigating circumstance, minimum period. So, ganun lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang epekto, maximum period. Offset rule, i-offset mo muna. Tingnan mo kung ano yung remaining modifying circumstance. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1, exception.
So, of course, my friends, you have, of course, a reply. To make it simple, a reply is an answer to an answer. Ayan. And the purpose of the reply is to transverse new matters raised in the answer. Transverse, dispute, di ba? Contest, transverse, new matters raised in the answer. But even though you fail to file a reply under the new rules, no? If you fail to file a reply, okay lang. Kasi exceptional situation lang. Ang rule na ngayon, all new matters alleged in the answer are been controverted already. So maski walang reply, all matters raised in the answer are being controverted already. If you talk
In relation to dation in payment, the answer is yes, because the debtor would offer another thing. Example, if the thing to be delivered is a sum of money like 20,000, the debtor instead would offer his carabao in payment of his debt, and therefore the consent of the creditors is absolutely necessary. Okay, he may not want the carabao. Okay. But in application of payments, is the consent of the creditor required? Definitely, there is no question because he would accept. Okay, then there is consent. However, okay, the question that would have to be answered is to which debt the payment should be applied. The third
Together, we can. Together, we can.
Walang natira, medium period. Pag may natirang mitigating circumstance, minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natira, medium period. Pag may natirang mitigating circumstance, minimum period. So, gano'n lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang epekto, maximum period. Offset rule, i-offset mo muna. Tingnan mo kung ano yung remaining modifying circumstance. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1, exception.
So, of course, my friends, you have, of course, a reply. To make it simple, a reply is an answer to an answer. Ayan. And the purpose of the reply is to transverse new matters raised in the answer. Transverse, dispute, di ba? Contest, transverse, new matters raised in the answer. But even though you fail to file a reply, under the new rules, no? If you fail to file a reply, okay lang. Kasi exceptional situation lang. Ang rule na ngayon, all new matters alleged in the answer are been controverted already. So maski walang reply, all matters raised in the answer are being controverted already. If you talk
In relation to dation in payment, the answer is yes, because the debtor would offer another thing. Example, if the thing to be delivered is a sum of money like 20,000, the debtor instead would offer his carabao in payment of his debt, and therefore the consent of the creditors is absolutely necessary. Okay, he may not want the carabao. Okay. But in application of payments, is the consent of the creditor required? Definitely, there is no question because he would accept. Okay, then there is consent. However, okay, the question that would have to be answered is to which debt the payment should be applied. The third
Together, we can. Together, we can.
Walang natira, medium period. Pag may natirang mitigating circumstance, minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natira, medium period. Pag may natirang mitigating circumstance, minimum period. So, ganun lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang ang epekto, maximum period. Offset rule, i-offset mo muna, tingnan mo kung ano yung remaining modifying circumstance. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1, exception.
So, of course, my friends, you have, of course, a reply. To make it simple, a reply is an answer to an answer. Ayan. And the purpose of the reply is to transverse new matters raised in the answer. Transverse, dispute, di ba? Contest, transverse, new matters raised in the answer. But even though you fail to file a reply under the new rules, no? If you fail to file a reply, okay lang. Kasi exceptional situation lang. Ang rule na ngayon, all new matters alleged in the answer are been controverted already. So maski walang reply, all matters raised in the answer are being controverted already. If you talk
In relation to dation in payment, the answer is yes, because the debtor would offer another thing. Example, if the thing to be delivered is a sum of money like 20,000, the debtor instead would offer his carabao in payment of his debt, and therefore the consent of the creditors is absolutely necessary. Okay, he may not want the carabao. Okay. But in application of payments, is the consent of the creditor required? Definitely, there is no question because he would accept. Okay, then there is consent. However, okay, the question that would have to be answered is to which debt the payment should be applied. The third
Together, we can. Together, we can.
Walang natira video video. Pag may natirang mitigating circumstance minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natirang medium period. Pag may natirang mitigating circumstance, minimum period. So, ganun lang kasimple. So, okay na tayo sa general rule, na? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang ang epekto, maximum period. Offset rule, i-offset mo muna, tingnan mo kung ano yung remaining modified na. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1, section.
So, of course, my friends, you have, of course, a reply. To make it simple, a reply is an answer to an answer. Ayan. And the purpose of the reply is to transverse new matters raised in the answer. Transverse, dispute, di ba? Contest, transverse, new matters raised in the answer. But even though you fail to file a reply under the new rules, no? If you fail to file a reply, okay lang. Kasi exceptional situation lang. Ang rule na ngayon, all new matters alleged in the answer are been controverted already. So maski walang reply, all matters raised in the answer are being controverted already. If you talk...
In relation to dation in payment, the answer is yes, because the debtor would offer another thing. Example, if the thing to be delivered is a sum of money like 20,000, the debtor instead would offer his carabao in payment of his debt, and therefore the consent of the creditors is absolutely necessary. Okay, he may not want the carabao. Okay. But in application of payments, is the consent of the creditor required? Definitely, there is no question because he would accept. Okay, then there is consent. However, okay, the question that would have to be answered is to which debt the payment should be applied. The third
Together, we can. Together, we can.
Walang natira medium period. Pag may natirang mitigating circumstance minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natirang medium period, pag may natirang mitigating circumstance, minimum period. So, ganun lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang epekto, maximum period. Offset rule, i-offset mo muna, tingnan mo kung ano yung remaining modified circumstance. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1, section.
So, of course, my friends, you have, of course, a reply. To make it simple, a reply is an answer to an answer. Ayan. And the purpose of the reply is to transverse new matters raised in the answer. Transverse, dispute, di ba? Contest, transverse, new matters raised in the answer. But even though you fail to file a reply under the new rules, no? If you fail to file a reply, okay lang. Kasi exceptional situation lang. Ang rule na ngayon, all new matters alleged in the answer are being controverted already. So maski walang reply, all matters raised in the answer are being controverted already. If you talk
In relation to dation in payment, the answer is yes, because the debtor would offer another thing. Example, if the thing to be delivered is a sum of money like 20,000, the debtor instead would offer his carabao in payment of his debt, and therefore the consent of the creditors is absolutely necessary. Okay, he may not want the carabao. Okay. But in application of payments, is the consent of the creditor required? Definitely, there is no question because he would accept. Okay, then there is consent. However, okay, the question that would have to be answered is to which debt the payment should be applied. The third
Together, we can. Together, we can.
Walang natira video. Pag may natirang mitigating circumstance minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natirang medium period, pag may natirang mitigating circumstance, minimum period. So, ganun lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang epekto, maximum period. Offset rule, i-offset mo muna. Tingnan mo kung ano yung remaining modifying circumstance. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1, exception.
So, of course, my friends, you have, of course, a reply. To make it simple, a reply is an answer to an answer. Ayan. And the purpose of the reply is to transverse new matters raised in the answer. Transverse, dispute, di ba? Contest, transverse, new matters raised in the answer. But even though you fail to file a reply under the new rules, no? If you fail to file a reply, okay lang. Kasi exceptional situation lang. Ang rule na ngayon, all new matters alleged in the answer are deemed controverted already. So maski walang reply, all matters raised in the answer are deemed controverted already. If you talk
In relation to dation in payment, the answer is yes, because the debtor would offer another thing. Example, if the thing to be delivered is a sum of money like 20,000, the debtor instead would offer his carabao in payment of his debt, and therefore the consent of the creditors is absolutely necessary. Okay, he may not want the carabao. Okay. But in application of payments, is the consent of the creditor required? Definitely, there is no question because he would accept. Okay, then there is consent. However, okay, the question that would have to be answered is to which debt the payment should be applied. The third
Together we can. 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 Together we can.